So my name is Connor Benedict. I am the co-lead of this working group. My other co-lead is Al Hassan. He's probably joining on phone, so he's present, but he's on phone. This working group has been dedicated to traditional knowledge and copyright intersections, and we started, or Al Hassan and I took over the working group last June, and have kind of been focusing on since nobody who is directly part of the working group considers themselves experts in the area, we have been trying to get experts to tell us a bit about what are the considerations that, around traditional knowledge collections and heritage collections and copyright questions, because there are certainly a lot. This session is kind of a mashup of two things. So on the one hand, we have a guest, which I'll get into in a second, but the other part is that this is our closing session. So this is the last session of the working group, where I'll just say at the end a bit about the other seminars that we've had and the report that's on its way out. And yeah, then we are kind of handing over the work to whatever working group modalities show up for the year 2023. Yeah, so that's who I am. So our session today, like I said, is a bit of a mashup. We have a guest with us today. Her name is Mehtab Khan, or I'm sorry, I didn't ask your pronouns, but Mehtab Khan is joining us today. We are going to learn about a paper that has been in revision, if I'm not mistaken. It's been updated over the last year with Creative Commons, and it's focused on traditional knowledge and copyright questions as well. So I think it's a good fit. So I'm very much looking forward to what we learn in this session. And yeah, if you guys have questions throughout, just write them in the chat. Otherwise, since it is a seminar, we can open up for questions towards the end. And if that's it for now, I will hand over to you, Mehtab, and the floor is yours. Thank you.
Thank you so much, Connor, and thank you everyone for being here. It's a pleasure to be speaking about traditional knowledge, Creative Commons, open licensing. I've been working on this for the past couple of years, thanks to my involvement with Creative Commons, and it's a privilege to still be doing that. And then the last couple of months, I was working with the Creative Commons team to update and revise a paper that was written back in 2018 about the intersections of traditional knowledge with Creative Commons licenses. The aim of the paper was basically to understand how traditional knowledge intersects with open licensing. And a key component of understanding that is to transpose and also understand the incongruencies and incompatibilities between how traditional IP structures connect or don't connect to traditional knowledge protection and preservation. And since open licenses are based on conventional IP structures, it's essential to understand what these gaps are so that licenses can be used in situations where they're useful instead of contributing to or exacerbating existing issues between conventional IP and traditional knowledge. So the paper, when it was first written, did some work around exploring those issues and recommended some ways that there could be better communication and understanding, and finding opportunities by connecting with communities directly and people working on the ground to learn what the needs are, where open licenses can be used, and how there doesn't necessarily have to be an incompatibility between conventional IP and traditional knowledge and the application of Creative Commons. The update to the paper, which I will do an overview of in this presentation, looks at the ways that non-copyright norms are now shaping the way that traditional knowledge is shared, preserved, and made available in digital format. And this might involve the use of open projects or projects by GLAM institutions, and various other tools that I can give examples of in a bit in my presentation. And the aim of the revision was to understand the ways that traditional knowledge and Indigenous communities are responding to the goals and needs that they might have with the sharing of their knowledge, and how they are relying on norms beyond IP structures to achieve those goals, and where open licenses can still play a productive and constructive role, and stay true to the values that the open licensing community holds. So I will first give a very brief overview of what the paper is, and just quickly run through what I talked about in the paper. And then I will do a brief summary of my revisions of the paper. And I would love to hear from the audience and the working group about where they think that we need attention, what kinds of projects or situations they encounter where there's this question about the applicability of Creative Commons licenses, and what open remaining questions they might have about IP that are not being addressed. So this is the general structure, and I would love to have a conversation afterwards. So I have slides, but they're not absolutely necessary. They were just for me to have like an outline, so we don't have to share them. I'm mostly just going to be relying on my notes, so we don't have to share the screen. Okay, so starting with definitions. What is traditional knowledge? It's a wide encompassing term that includes several categories of knowledge. This is reified and it's been institutionalized through instruments on an international level, and also at national levels by sui generis regimes that various countries have passed for the protection of traditional knowledge. It can include more tangible forms of knowledge like art, primary sources of data, images, sculptures, objects. But it also includes, other forms of knowledge like spiritual or cultural connotations, practices, lifestyles, behavioral information, histories. It includes, all aspects that you can imagine that relate to the cultural and existential identities of a particular community. And there are in existence a patchwork of international and national instruments that provide protection for these forms of knowledge, some within IP and some outside of it. And there are sometimes categories that are not an easy fit. And that is, usually a contestation or dispute at a national or international level to include and cover those categories. In recent years, there was also a treaty being negotiated at the World Intellectual Property Organization on protecting traditional cultural expressions. That has not passed yet, but at least these issues are being discussed at the national level, and there's space for people who are interested in following how these negotiations are taking place and who's involved. And there's a whole discussion related to it. This was outside the scope of the paper, but my intention was to show that there are structures in place already that cover parts of the issues that we are concerned with. Now, it is important to identify some of the elements of copyright law that sometimes intersect and sometimes clash with these forms of traditional knowledge that need protection and recognition. So copyright law is based on a number of assumptions about how society functions, how to balance interests between copyright owners and the public. There are notions of public interest that are embedded in copyright law. I can speak about US law, but Creative Commons is a global project, and you often encounter copyright laws in various countries. So these notions might differ, but there are some core key elements of copyright law that are kind of universal, or at least in modern copyright law, that everybody can understand and get behind. So the first of these elements is the idea of authorship, and the idea that there is an identifiable person or entity who will exercise the bundle of rights that are granted by copyright law. And this is sometimes possible to identify for like a particular artifact, or, the person who collects knowledge or preserves it, they might be able to act as the purveyor or like the author of that piece of work. But it is often difficult to apply concepts of authorship because the concept of authorship comes with rights. It comes with, exclusivity. And that sometimes doesn't align with how a community wants to engage with that particular piece of knowledge. It might be community owned, it might be more fluid, it might not be in a tangible form. And so sometimes it becomes difficult to apply the idea of authorship. It also, shows that some of the ways that we achieve or identify what right applies gets lost in translation, because it's assumed that there's this one person who was involved in the labor and creation and creative process of whatever you're trying to protect, but that might not be the case. That might not be the history of the process by which that particular piece of knowledge was developed. What has happened in some cases is that traditional knowledge is then not seen as the product of labor, but as like natural or raw materials that is then built on. And this idea is also problematic because it doesn't recognize the use and permission protocols that might be attached to it. If this is an issue for open licenses, because attribution is a key part of a lot of the terms involved in open licenses. And so if you can't attribute, then it's difficult to apply a license. It also affects preservation efforts. So back in 2019, when we were having conversations with people who are on the ground, working with Indigenous communities and trying to make knowledge openly available, we heard from people who were doing preservation work for languages, for instance, who work on preserving rare languages, and they want to make those recordings and video and audio pieces available so that more people are aware of the language. But then there's an issue of like attribution. Who owns those copies? Who exercises control over those copies? Who's responsible? How would commercialization or like restriction or commercialization work? And so people involved in these preservation efforts also encounter issues with ideas of authorship. The second assumption on which copyright is based is the idea of originality. And this is tied into authorship because you assume that copyright can only ascribe to something that is original and has not previously existed, or if it is previously existed, that is different enough to warrant protection. But that might not be the case with how particular kinds of traditional knowledge are developed and expressed. And that leads to the third kind of assumption within copyright law, which is expression in a tangible form is necessary for copyright protection. Like you can't protect ideas, they have to be expressed in some form. And sometimes that can be difficult to translate and transpose because this knowledge might exist in the form of practices, it might be handed down orally, it might just be meanings and connotations, it might be sacred meanings related to artifacts that are displayed in museums. And so those things are not protected in the ways that conventional IP structures function. So given that these are the assumptions, or these are the basic, underlying philosophies behind copyright law as it exists in modern societies, there are some issues that we have to be wary of when we're applying, these concepts to traditional knowledge. We spoke about this earlier in the sense that, we don't want to see traditional knowledge as only like raw materials or just naturally existing and without any form of protection so that people can just take and build on it. We also don't want to reify and institutionalize ideas that the public domain is where traditional knowledge exists. The public domain as a principle is seen as positive and constructive because it helps people access knowledge and key information and share, and it also fulfills the key goal of copyright, which is to further public interest and allow people to access knowledge. But the ideas of public domain can sometimes clash with how traditional knowledge is shared, especially on the internet, and how it might not fulfill goals of preservation and control that an Indigenous community might want to exercise. Another a notion that we have to be careful about when we're talking about copyright is that we need to introduce more flexibility and fluidity in how we understand authorship, how we understand inventiveness, how we understand tangible expressions, all in the form of like categorizing and defining what we're seeking to protect and who has the right to exercise control over it. And this has to be done on a case-by-case basis so that, you know, we can understand the needs of that particular piece of knowledge or piece of work, and see if copyright applies and how it applies, whether you need to apply, whether you need to rely on you know, more sui generis protocols or not. And in the paper, you know, we hope to make this available after the revisions are finalized. I have discussed, you know, these concepts of copyright, and I've discussed how it applies to traditional knowledge. Then I've also talked a little bit about the ways that digital tools have responded to these incompatibilities and these gaps in how traditional knowledge is to be protected and shared, and how copyright might not always meet the needs of the communities involved. And by and large, these tools are customizable. So I'm sure that you're already aware of these tools like Mukurtu, rights statements, local contexts. These are some of the ways that some rights reserved models and customizable labels and models have been applied and have given agency to communities to apply and define the ways that they share their knowledge. This is important to also acknowledge because we see an implicit recognition then that on the internet, it's very difficult to control and map out how information will be shared. That's why open licensing exists, because you want to make it easily available for people to share knowledge without encountering liability or you know, nuisance notices about copyright infringement. Like, you want to make it easier to share knowledge. And so customizable tools, and on one side, help do that because it allows the communities to exercise some agency while facilitating the flow of knowledge. But it also is sometimes difficult to implement on the ground because it means that the generalizability, which is a feature of open licenses by and large, is no longer the case, because you apply custom versions of a license to only a specific kind of knowledge. And from the usability and user experience perspective, I'm sure there are people who have worked on this who might know better about what users prefer and what's easier. But sometimes, you know, the generalizability gets compromised if you have customized solutions. And sometimes it's the lack of awareness about these terms, it's the lack of awareness about how custom solutions work and how they might intersect with copyright law in a particular country. So it makes it a greater barrier to use customizable tools, and it is an issue for open licenses that are based on general terms to kind of reconcile and deal with this issue. So I talk a little bit about the existing tools that are there to respond to some of these concerns, and they have a lot of positives, a lot more positives in my opinion than the issues that I've just mentioned. The first version of this paper ended with some recommendations for how to begin conversations about these topics and who to involve, you know, how to make it more mainstream and like more increase awareness about what these intersections are. And the revisions to this paper are focused on the ways that sharing of traditional knowledge and preservation efforts, as well as like technologies that are being developed using these you know, databases or these repositories of traditional knowledge are being used. So my aim here with the revision was to show that, you know, copyright law is not the only source by which we understand how knowledge is to be shared online. And non-copyright norms that are more expansive in some ways, such as the concept of data sovereignty, was the focus of this revision. So I talk a little bit about the concept of data sovereignty and like the concepts of open data and what the demands and goals of these these norms are, and how they apply to how traditional knowledge is being shared, and how it intersects with how IP has not been able to meet all of the needs of the communities. So what is indigenous data sovereignty? So it specifically just refers to the right to govern the collection, ownership, and use of data, and it is tied to the identity and territorial sovereignty of an indigenous peoples. At its core, it's about political self-determination, it's about agency, and it's about exercising control and involvement over knowledge that defines who these people are. And this could include knowledge that exists within IP, and like, include the exercise of the rights given by IP, but it's beyond that. It's about like having more, of an agency over the collection, ownership, and application of information. So I talk a little bit about what this concept of data sovereignty is trying to do, or what the overarching goals are. And then I talk a little bit about how this might apply to instances where open knowledge is available, and how what kinds of demands the data sovereignty or indigenous data sovereignty movement might make when knowledge is made openly available. So I talk a bit about how the recognition of indigenous protocols will be a part of indigenous data sovereignty, and how that should be taken into account before any attribution or any preservation or collection efforts are made. And this might be, a museum making a collection available, making the effort to learn how, if there are any other protocols or meanings associated with the artifacts or knowledge that they have in their collections, and how they might apply, how these protocols may apply before they make that collection openly available. Data sovereignty also might entail recognizing that knowledge is created both at the system and a system, individual, and community level, and that it's more dynamic, and would address some of the concerns that the community might have about the authorship and ownership requirements that IP has, and doesn't quite capture the dual nature sometimes that might exist with regards to who exercises control. I also talk a bit about how we can make research practices better by recognizing notions of indigenous data sovereignty, how collection is taking place, what protocols are applied to preserve the wishes and protocols attached to whatever is being collected, how it is shared, who it is shared by, how long it is openly available. So all of those things need to be taken into account in research practices. And this might be done on like private level, where somebody's going and collecting genetic information from a community, and does not take into account that there might be other protocols attached to sharing that information. But it can also just apply to the example that I gave earlier about language preservation. And I also then talk in the paper about what we need to be wary of when we are talking about non-copyright norms, and what are the consequences that might occur if we don't take into account some of these emerging norms and goals that are being defined with regards to sharing of knowledge. So the disconnect between what data sovereignty entails and how open access policies are formed might trickle down into how we understand core aspects of open licenses, like who is the author, how is attribution going to work, how should it be shared, what platforms can it be shared with, how much involvement can you have from a community, or should you have from a community before you make it shared. So if we're going to define open access policies in the first place, they need to be taking into account these goals of indigenous data sovereignty before the goals or before the open access policies are implemented. The last part of this paper actually looks at examples of the constructive use of open data that can actually facilitate some of the goals that indigenous communities might have. So I give several examples. There are a number of AI tools, for instance, that are being used and built upon open data to create better representations of the communities and their artifacts. There are tools that are being used to make museum collections available. And obviously that entails the use of data that might be based on traditional knowledge, and how the communities themselves might be involved in creating these tools and defining the terms and the use of these tools. So there are examples of that. There's also, I talk about one example of this tool called Curationist that some people might be aware of. It's a cultural heritage content generator that's built on open data. And so there are positive examples of where open data is actually the facilitator of making traditional knowledge available in the first place to create tools that further foster inclusivity. So, it's a matter, in my opinion, of finding ways to find intersections that might be positive and productive. We don't have to see what I talk about in this paper as like an indictment or as a proclamation that the traditional knowledge can just not be shared using open licenses. Like, that's not the case at all. And I talk also about how there are examples where open data is being used to improve taxonomies and create better terminologies for the descriptions of indigenous data that are then fed into search engines. And we'll see this coming up more as we see, with ChatGPT and other language generating models that are relying on data sets that, use metadata and taxonomies. And if those taxonomies and metadata are inclusive in the first place, the tools that we develop are also going to be more inclusive. I conclude the revised version of this paper by saying that we need to highlight the ways that there are productive uses possible, but we also need to recognize where the gaps are, and also recognize that this discussion of open licensing use now goes beyond copyright and goes beyond IP, and we need to be taking into account what these non-copyright norms are that are shaping the sharing of knowledge on the internet. With that, I would love to hear your thoughts, and I'm happy to take any questions. Thank you.
Thank you. Thank you so much for sharing your paper with us. Before I go, does anybody in the group have a question they would like to share with Mehtab? You're welcome. Yeah, go ahead.
Okay, hello. I enjoyed it from the beginning to the end, and I'm really interested in learning more. Well, I have to tell a little bit of background. We are working on a project in the Wikimedia environment. It is bringing the UNESCO intangible cultural heritage items into Wikimedia. Because it is the celebratory year, the 20th anniversary of it. And we also have a working group and a webinar upcoming, which we haven't planned, about how to make the guidelines for this year-long activity. What would be the best practices of creating new documentation or bringing existing documentation of intangible cultural heritage into the Wikimedia projects, because it is from from the start, it is a controversial challenge, and especially as maybe the Wikimedia platforms are the most challenging ones to apply novel practices in. So, well, there are many aspects that I would like to bring up, but maybe what does come to your mind first might be my question, like what would be the first level to address this whole issue, and then I can pose more questions if we have time.
Thank you for that. That sounds like a really cool project, and I'm sure that it's very complicated also to implement. The first thing that strikes me is what kind of response are you expecting? So are you expecting that people, like, for example, I'm thinking of photographs of these, piece, like this heritage, for instance. Are there going to be claims against those photographs? Are there like protocols around sharing photographs? And what other ways what other formats are you expecting to share intangible heritage? Because that's where IP would apply. And in terms of like, other norms and ethical concerns, I guess that would depend on the geographical location and the rules and norms that apply to that particular location and whatever community is involved. And you would have to take that into account as you're designing or formulating ways to share that. Because I'm imagining that it just would be a different response depending on where the heritage is from.
Yes, I think one of the things is to create guidelines for approaching in situations where new documentation is made, and then finding out a way to record consent and maybe share, and thinking about the Wikimedia platform, like where would that consent live, and how would it be expressed? And then, well, ideally, I can imagine that we could apply some kind of tools, the kinds, well, that you mentioned on the Wikimedia platforms. I don't think that would be such a big problem to have labeling. I think it would be easy, but to be able to enforce it somehow, maybe more problematic, like, I would be very, very happy to talk about this with you, or invite you to also think about this together with us.
That definitely sounds complicated, for sure, and important. So if there's anything I can read about that to learn more, that would be wonderful. And then I think I would be able to formulate my thoughts better.
I will paste the link to the project. It has some, it is not focusing completely on the ethical questions yet. There are some references to it, but it's not exhaustive for that part yet.
Thank you, Susanna. Does anybody else have a question? Claudia, Ellen, Alhassan. Okay. So one question I had was, if we're thinking about an institution that has a collection, what do you think the first thing is that they should consider before putting a collection in an open access setting?
I think that would depend on the museum's own practices and how they preserve or define or have sharing strategies. Like if they're pictures of paintings, for instance, then it would be a very different set of issues than if it was just like a video recording or an audio or some ways that people would experience it very differently than just like looking at the picture of a vase or an artwork. So it would depend on what they're sharing, I think. And I think it would also depend on identifying if there are any indigenous protocols attached to that particular form of knowledge. If it's a sacred practice, then what are the foundations attached to it? If it's a piece of artwork, then they also have to be careful about, I mean, this is difficult to control, but, you know, what if somebody copies the design? And what if somebody, you know, uses it on like commercial products like clothing or you know, whatever other objects. So that's difficult to control, but it would really depend on who the community is and if there are any protocols attached to it.
And I know you gave the example of the curationist, and that's more on the technology and on the like it's a platform that exists and they do the curation work. Do you have an example of an institution or a collection that's kind of leading the way, or that you thought was starting to engage with these topics with their collection, that you, that kind of is a good example to look at? Or
I'm sorry, could you please repeat?
Yeah, sure. So you gave the example of the curationist, which is more on the digital side of already having the collection. I was wondering if you have an example of an institution that has a collection that's kind of leading the way, or is a good example if for institutions that might have a similar collection or are facing the same questions.
So I briefly mentioned in the paper, there are examples of communities collaborating directly with museums to use 3D technology to create replicas and make those images available online. So that really depends on that particular museum and that particular community. But I think the key part of that is not just that they're collaborating, but that they're using a specific kind of technology. So, you know, when you think of AI tools or you think of 3D technologies, I think it just represents a lot of opportunity. And so it really depends on how these technologies are used for us to say that, you know, this is a great example of using that. Okay.
Thank you. Great. Does anybody else have another question for Mehtab? Or Mehtab, do you have a question you might want specifically answered by someone?
Well, I think I would love to hear from people about how they've encountered, you know, the intersections of traditional knowledge and open licenses, because I can write about this and like do my research, talk to people, you know, talk about doctrine because I have a legal background, but I'm always interested in hearing from people who are working on the ground and how that is actually, you know, really important for how open access policies are shaped and then implemented. So I can talk about what's like legal and not legal, what is ethical and not ethical, but sometimes I feel like my discussion is a little bit abstract. And so, you know, I'm happy to share my email if people want to reach out and talk about examples that they might have encountered, or if they find somebody who is dealing with these issues, you know, I would love to hear about that. I'm just going to type in my email here.
Great. So you guys are more than welcome to reach out to Mehtab then. Thank you so much. And I guess what I will do now is just kind of semi-segue into closing our working group. So I'm just going to give a brief reading of the previous two seminars so that they are in this recording. So the seminars that we had were actually with Jane Anderson from Local Contexts and with Erna Lilje from the World Heritage Museum in the Netherlands. So I think what I want to highlight from the first seminar, which was with Jane Anderson in Local Contexts, is they have developed a series of tags, we'll call them tags, to indicate how traditional cultural heritage can be used and what it represents. And their approach is a very bespoke approach that is focused on basically a case-by-case basis. They deal with things case by case, connecting communities with collections with institutions. So they try to kind of go through the whole process of like, okay, what does this material mean? How can it and should it be used? What are the markings that we need to attach to it? And how should the institution create or show this information so that people that want to engage with this material can use it? So that was the first seminar that we had. And I think her question for Creative Commons was what's the next step for enforceability? Because at the moment they are just markings, they just kind of communicate information, but it's not something that they can enforce, and it doesn't have the same strength as a copyright license. So the question was, how did these things evolve in that direction, or what needs to be communicated in the future around that? Then our second seminar was with, as I mentioned, Anna Lilje from the World Cultures Museum. She is the curator of the traditional knowledge collections, and her seminar focused on her collection. She's from Papua, and the collection is traditional cultural heritage from Papua. And I think what she wanted to emphasize in her seminar was that the institution has a responsibility, or has been given the responsibility, of preserving material. And the fact that they are working to open up the collection means that material that has vanished, or practices that have vanished locally, actually can be essentially rediscovered. And that was kind of her way of saying that there are unforeseen or unpredicted benefits or interesting ways that it evolves, that preservation and open access creates value. Because although the collection is not in Papua, people from Papua can access it, which she explained that traditional bead making, bead weaving method was essentially rediscovered for their community. That was the example that she gave. Yeah, so to kind of sum up those two, yeah, definitely some questions still to be explored in hopefully a future working group on the subject. I think I'm going to leave it at that, unless somebody has something they would like to close off with as well.
Is there a way to like follow the working group and like what you're working on next year, or what your priorities are in 2023?
Yeah. So for 2023, we don't have a program yet. Actually, the Open Culture platform from CC doesn't have a program yet. So until that gets more solidified, which is actually probably happening tomorrow, I can't say what's going to happen for this working group. What I can say is that, what was I going to say? This recording and the recordings from the other two seminars will be available with the report. So all that is accessible starting at the end of the week for everyone, which is great. And yeah, that's kind of where we're at. So thank you everyone for joining. Thank you, Mehtab, for your presentation and for giving us all these insights. And yeah, have a great day.
Thank you so much. Thank you for having me. I look forward to following your work.
Great.
Bye.
Bye, everybody.